A lot of this stuff has been staring us in the face the entire time. The problem is that we don't understand what we're looking at. In front of you is a state of Texas driver's license, okay? It's obviously a fictional driver's license. But if you look at the top, it has state of Texas or Texas. It has your name written last name, first name, or last name, first name, and then the middle name is last, okay? Which is in incorrect order, but of course it's incorrect because it's a decedent account. It's a Patrick call it a mortmain account or a dead man's account, okay? But if you look right here, this name is not written in the same order as the name on the driver's license, okay? This signature at the bottom is an authorized representative. This authorized representative is binding the state of Texas as the obligor over this driver's license. The obligor or the obligated party, okay? Because on the application for the driver's license, we issued a social security number and we were acting on behalf of the U.S. Department of the Treasury. And we signed as such on the application granting the state of Texas $11.2 million to fund whatever public endeavors they needed, making us creditors to these institutions. Now, these accounts, okay, are debtors to us. Those accounts are holding our assets. If you look at your driver's license, look at your passport, it is the same way. Your name is written last name, middle name, first name. Okay. And then at the bottom, your name is not signed the same way as the name is written on whatever document. It is signed in a different manner. Okay, your first name, in some cases, your first name, middle initial, last name, or some of you sign first name, last name, but your name is not signed the same way as the name is written on your driver's license or your passport. And I want you to take a look at that. Okay, what we are doing in these contracts is binding the corporations to the terms of the contracts. We simply act as authorized representatives, okay? Our fictional person is acting as an authorized representative on behalf of the creditor. If that makes sense, the creditor is you. The creditor is us. Like, we are the only ones that can give substance to the assets because we really have labor and time. The corporations don't. We are turning our labor and time into assets, okay, and investing those assets into different corporations, state of Texas, Geico, your mortgage, whatever the case may be. The reason that we set up these corporations were to make them thrifts or investment vehicles, okay, to help us grow our wealth faster than we would just on labor alone. Okay, so it wasn't a bad idea. The problem is, like I say in all my videos, no one taught us how to govern. No one taught us how to manage our financial affairs. So as a result, we're being punished for it. Okay, one of the documents I wanted to go over is the Form 56 because Patrick he did a recording where he addressed the Form 56. And on the Form 56, I don't have a copy in front of me, but it's in his files. And on that Form 56, he appointed a judge as fiduciary. Okay? He appointed the judge as fiduciary over his decedent, which is that name written last name, first name, middle name. Okay, he appointed that judge. If you listen to Patrick's videos later on, some maybe about a year or so past, where Patrick comes back and he says, well, we're not supposed to appoint the judges or whoever, the clerk of the court, we're not supposed to appoint them as fiduciaries over these accounts. Because if you read the instructions, it states that the fiduciary has to be the one to sign the form. But let me tell you guys what I just found. There's more. When it comes to Form 56, which is used to notify the IRS of a fiduciary relationship, there are a few key points to consider. The fiduciary's name. The fiduciary is the person or entity responsible for managing the financial affairs of another, the beneficiary. The beneficiary's name should be accurate, not the beneficiary, sorry guys, I misspoke. It says the fiduciary's name should be accurately listed on Form 56. The entity signing the Form 56. While the fiduciary's name is typically the one uh, that signs Form 56, there are situations where a different entity may sign. Listen to this again. I got this out of Section 6306 of the IRS Code. Entities signing the form. While the fiduciary's name is typically, meaning that, well, usually the name on the Form 56 is the person that signs the form, not in every case. While the fiduciary's name is typically the one that signs Form 56, there are situations where a different entity may sign. For example, authorized representative. If the fiduciary designates someone else, such as an attorney or accountant, as their authorized representative, that representative can sign the form on behalf of the fiduciary. But wait, there's another entity, a corporate fiduciary, which is what all these courts are. All of these courts are corporate in nature. Every single court that sends you a notice, hey, or a summons, you got to come. These are all corporate courts, every last one of them. Okay? A corporate fiduciary. If the fiduciary is a corporation or other legal entity, an authorized officer or agent of that entity may sign the form. So Patrick was right when he first released the 56 stating that we make them the trustees on the Form 56s. Yes, we do. Because the reason for that being, many of these securities have to be brokered. And he says that repeatedly. And anybody quote me, fact check me on this. Anyone that listens and studies Patrick's teachings, studies his documents, he says repeatedly that the court is a brokerage. It's a brokerage. The state is a brokerage. These are all brokerages. The attorneys are brokers. He says this repeatedly, okay? So, for example, if your house went into foreclosure and someone claiming to have purchased your house at some auction, right? What they do is after they purchase the deed of trust at the auction, here is where the fraud begins, because now they have to initiate a court proceedings against you stating that they are the landlord and you're not paying rent, and so you have to vacate. Or they try to have the judge sign off on some type of forcible detainer to get you out of the home, and then they use the deed of trust as evidence and the purchase order to show, well, oh, I'm the new owner of this property because I purchased the deed of trust. No, what you purchased was a lemon. That's what you purchased. You purchased a lemon. You purchased a bad vehicle, a bad investment vehicle, and you better go back to whoever you bought it from and get your money back, because you're not taking nothing from me using paper. So they're trying to utilize or use paper in order to take real assets from us. So the whole, any eviction or like any forcible detainer of like for foreclosure sale or after foreclosure is all fraud. And like I said, what they are doing is conspiring together, and the judge is like, okay, well, submit prima facie evidence that you're the owner, and then they put your deed of trust on the record. Well, technically what they have done is they have deposited your asset with that court. The court, whether you realize it or not, is a financial institution. Yes, it is a brokerage. Okay, it is a brokerage, it is a financial institution. So this person pretended to be the plaintiff, stating that, oh, I bought their house at this auction. Okay, so I'm the new owner. They went and deposited your check, which you were the authorized representative, the creditor of that document, of that check. You were the creditor on that document. They now are trying to use your credits to steal more assets from you, if that makes sense. That is what they are doing, and the judge is in on this, okay? And so Patrick talks about this. And I'm gonna play him for a little bit so that you could hear him giving his thoughts and opinions about the 56. This may run for, who knows, it could run for about 10 to 12 minutes. I'll pause it periodically, going through the audio recording so that you can hear what he says. But he was absolutely correct in how we were supposed to use the Form 56. And I found that reading, like I said, reading the IRS code. And I tell you guys, like, I don't just make this suggestion to you guys, like I do it myself. I read these forms repeatedly, and each time I read the form, it's like, oh my God, I skipped over this. Now I see a broader way or a different way, because there are multiple. One form does not just have one use. There are multiple ways to use the 1099 OID. I've proven that to you. I've shown that to you. There is more than one way to use a Form 56. There is more than one way to use a 1099-C, but you wouldn't, think of the various ways you could use these forms, A, unless you define the words, and B, constantly, repeatedly reading it over and over and over again until it starts to kind of like make sense in your mind. Okay, so listen to Patrick talk about this Form 56. And I want people who are dealing with foreclosures, repossessions, okay, I know Patrick said at one point that, oh, you don't want to appoint them as trustee. Yes, we do, because we need to make them liable for their negligence. Okay, they have to be liable for their negligence. So right now, and he'll say it, you'll hear him. Let me shut up and just listen to Patrick. He is a wealth of knowledge. Just listen to what he says.
Somebody else 2,000 years ago, he basically left. Okay? I've talked and I've talked and I've tried to help in every which way I can. Now I need to basically go and complete helping myself. Okay? You may think that that is the wrong thing, but it's not the wrong thing. There's only one way that you guys are going to get off the fence, and that is for me to stop giving you anything and say it's done. Well, it is done. The last documents I submitted into the court are right. The only thing that was lacking was that we had to give a body or a form to the name only judges, U.S. attorneys, clerk of the court. See, they're operating under the protection of just having a name only. So that is the fiction that basically is making the rulings and everything else. That's what gives them their protection. You have to take their protection away from them under color of law, and you have to expose them to reality. Okay?
You have to take their protection away from them, expose them to reality. They are handling our assets out here. Okay, we put these assets out here not knowing that we were investors. I get that. Okay, but they are using our assets against us in a sinister way. They are robbing us. Okay, they are taking from us, and they are using our ignorance. Okay, the fact that we don't know that we're just common folk. Okay, we're just common everyday people. They are using this against us. Okay, so that attorney general is a corporate officer. The governor is a corporate officer. The judge of the court is a corporate officer. These are all corporate entities, okay? And according to the IRS, these are not my words. According to the IRS, a corporate fiduciary, if the fiduciary is a corporation or other legal entity, an authorized officer or agent of that entity may sign the form. Yes. And Patrick, I don't think there are some things that Patrick's he is like, I don't want to say that I'm like him because I'm not. I'm nothing like him. Like, I don't nearly possess the knowledge that he does. I am trying to ascend to that level, but I don't have it at this point in time, and I'm working my ass off to get to where he was in his understanding. He would say in some of his videos that you can sign these documents on behalf of the corporations, and like that, it kept flying over my head, flying over my head, flying over my head. But after, like I said, repetition, listening to the videos repeatedly over and over and over, listening to him say that, hey, listen, you're a trustee to them, you are a authorized representative, you have the authority to sign a UCC1 on their behind, to sign a whatever document it is. So like, for people that are in foreclosures, you can literally do your own satisfaction of mortgage, and you can use the logo to the mortgage company and notarize it yourself and send it into the county and have it recorded and put a 56 around that clerk's body so that she can stop playing games. You continue playing games, and you know good and well you are managing my assets. Okay, once, and he is correct about that, and I swear, go and read that IRS six, I think it's the 6306. Go read that publication, and it is there in black and white. It tells us that we absolutely, you, the name of the fiduciary can be different from the person that signs, that binds the fiduciary to the notice, to the agreement. Okay, but in Patrick's example, he thought that, okay, I have to create the 56 and make the judge the fiduciary, but I have to send it over to the judge to sign, and they never signed it. Now, let me tell y'all my own testimony. I did this like a year and a half ago when I first started with this whole foreclosure fiasco. I sent a 56 over to the clerk and told her to sign it, and of course she didn't. But I did not know at that point in time that we can sign on behalf of the clerk. So we put her name, that clerk is acting as a trustee. Okay, and her name goes as the fiduciary over that decedent's account. And so if you go and look on the county record, I am almost certain of it that your name is written last name, middle name, first name. And the reason that that name is written like this is because that account is offshore. That's what makes that account foreign. These accounts are not operated on the land jurisdiction. They really are offshore accounts. Okay? And that clerk is uh she is not negligent, okay? Only when they sell the property and they do not assign the proceeds to us. And the reason that they do not assign the proceeds to us is because we do not come forward. We do not come forward and claim that, hey, you sold that deed of trust, Oh baby, you owe me, you know that money, that money belong to me. Who you put that money in your pocket? And so since we don't come forward and claim the money as ours, they claim it, and then they turn around and they take our house or they take our car. And so as I was reading over that publication 6306, and I started to read the form 56 again, okay, did I realize that, oh no, we absolutely can. Let me find it. Where is it? That's the. We absolutely can fill out these Form 56s and appoint the judge or the court, okay? And in these instances, I'm going to go through the 56 and I also want to go through the instructions, okay? In this instance, okay, you're going to do a 56. The 56, it notifies the IRS of fictional persons, okay? Like when you think of Judge Joe Brown, okay, you think of Judge Joe Brown as like just an individual person, okay? So on a 56, Judge Joe Brown's name would go on the 56, but the 56F is the court where Judge Joe Brown is working for. That is the financial institution that is holding the asset. So the 56 names the individual, even though I'm aware that an individual is a corporation, it could be a trust or an estate. I am aware, but the word individual can be used interchangeably. Okay. The individuals go on the 56. The financial institutions go on the 56F. Okay. So if you are dealing in a foreclosure, a repossession, okay, normally with the repossessions, let's say you have an account with Ally Bank or whatever the case may be. If Ally Bank or Capital One, and you guys know that I use some of the same corporations that I've done business with, okay, that Form 56 will go, that 56, matter of fact, okay, I had to think about it for a second. Yes. So on that 56, okay, if Ally Bank, in some cases, they may appoint, like when they repossess from me, okay, when they repossess from me, they hired an attorney to facilitate the repossession. When they hire an attorney, that attorney now becomes the fiduciary. So when you enter that, we're going to go through the form, okay? The name, okay? The name on these 56s is going to be your name written backwards, because for a mortgage or a car contract or whatever the case may be, the one thing that they all asked you for was some form of state ID. They wanted to see a driver's license, some form of government issued identification. And on all government issued identification, that name is written last name, first name, middle name. Go and look at your documents. And then at the bottom, your authorized representative's name is written, like in my case, okay? My offshore account is Wilson Christina Meredith. But when I sign, that authorized signatory, okay, signing on behalf of the taxpayer and the financial institution, the account and the financial institution was Christina M. Wilson. That is a different entity. That entity that signed that contract is not binding upon the person that signed it. When we sign it, we're binding them to the terms, not the other way around. On box number 1, the name is going to be written last name, first name, middle name. If you don't have a middle name, it's just going to be your last name and your first name. The identifying number in the instructions, okay? Please, please, for the sake of all things holy, so that y'all can stop cussing me out, please read the instructions, because I say this all the time. Do you know that, like, the reason there are so many different factions or churches, right? And you wonder, like, okay, how did we get Seventh-day Adventists and Baptists and Mormons and Jehovah Witnesses? Like, how all of them are reading the Bible? How are they all coming to different conclusions about the interpretation of the Bible? And that's what it is. It is because they interpreted the instructions of the Bible differently. Okay. And so rather than this, my channel or my business being somewhere that kind of tells you what it says, I tell you to read it for yourself, and you come and you tell me, do you agree with what this says? Do you agree with my interpretation of it? And if you do not agree, this is how iron sharpens iron. You come and you joust with me, you duel with me, okay? And you tell me this why I don't agree with you, okay? And may the better argument, or not argument like in a nasty way, but we're trying to get to the bottom, like which interpretation makes the most sense. And debate is the best way to expose that, okay? But in the instructions, it says for, where was I? I was talking about the identifying number. Okay. Where is it at? Okay. If you are acting for an individual debtor, or other persons whose assets are controlled, the identifying number is the Social Security number or individual taxpayer identification number. But if you are acting for a person other than an individual, and in 6306, they say if you are acting for a person other than an individual and they have estate and they have trust in parentheses, if you are acting for a person other than an individual, and in parentheses they have an estate and a trust, they do in the publication, the IRS publication. So they have an estate and a trust. Hold on, everybody, sorry. Sorry about that. I had to pause for a second. Okay, so in parentheses, they have an estate or a trust. If you are acting, I'm going to plug that into the sentence so that you can, and y'all, please understand. Translation, okay? When reading these instructions, the best advice that I can give you, if you are reading instructions, okay, and let's say you come to a word that you don't understand, meaning that as you're reading, this word does not translate in your mind. Like, let's say if you're reading a sentence and the word deceitant pops up, okay, and if the word deceitant does not translate in your mind, you must stop. You get a dictionary and you look at the different similar terms for a decedent, and you'll find like a decedent can be a natural person or it can be an account. Okay, so let's go with account because we know that decedents are corporate accounts. Instead of using the word decedent, replace decedent with a corporate account, and then you try to read the sentence again with the word, with the replacement of the similar term or word or whatever the case may be. You replace it and then you read it again, and this will help translation. You have to understand what it is you're reading. You can't just read it. And the reason that I'm reading it is because Christina told me to read it, but I don't understand what I'm reading for myself. You cannot approach this with that type of mindset. You must translate. Every word must translate in your mind. This is one of the reasons that Jesus' language, Aramaic, became obsolete. The reason that it became obsolete was because the money changers was changing the words little by little until now the people don't speak Aramaic no more. Now the money changers got the people speaking. I think it's like Arabic is the closest language to Aramaic, but it's not the same. Okay, there are some people that say that they can read Aramaic, but but others are saying that no, the that language is really dead. It really is a dead language. So that's what happens, like with words and terms. Okay, like they use word male and female. Well, those are corporate terms. The actual word that we use is man and woman. Parent is a corporate term, but the actual terms that we use in the natural world, in the real world, is mother and father. Okay, so this is how languages become obsolete because people are not aware that slowly but surely they're changing our usage of certain words and then assigning new definitions to them. So you have to become like you have to be aware of just about as many things as you can become aware of. Okay, so back to the instructions. Okay, I am reading the section of the Form 56 instructions that talks about the identifying number. If you are acting for a person's other than an individual, an estate, or trust, the identifying number is the employer identification number. The EIN is going to be that EIN number for that judge's courthouse. We don't know the judge's social security number or none of that. Okay. We're going to enter the that EIN number for that court. It is not even a real court. It's a private business center. Okay, that's somebody's private. That's a private place of business where a bunch of people go in there and call themselves judges in their legal name and pretend to have some type of damn authority over us. So that is what the identifying number is. The decedent's social security number is social security number with dashes. Okay, the judge's name. Now, for you individuals out there, you individual bankers out there, okay, that set up your own estate, private bank, and foreign grantor trust. Kudos to you because now you have been exposed to certain acronyms such as TTEE. You know that if you set up your foreign grantor trust, that the acronym TTEE is what you put on the end of a name to indicate that they are a trustee. The trustee is responsible for the taxes. They are liable for the taxes. Okay. Your, like, for example, your deed of trust or your promissory note, whatever the negotiable instrument was, if this court is talking to you, they are in holdings. Okay, they are in. Remember, I told you that a lot of these corporations are holdings companies. They are in holdings, or they have received your assets. And since you don't know what's going on, okay, they're hoping that some negligence can take place and then they can get an easy victory. Now we know that you absolutely can sign this Form 56, binding them as a fiduciary. Now, that bond that we have, okay, because before, like, there have been a couple of people that came to me and asked me, like, how do I file a claim against a clerk's bond? Okay, I did not have a lot of advice on how to do that because I have not had to do that myself. So I'm going off of what I understand the instructions to be. However, I wholeheartedly believe now, and after reading that publication 60, I think it's 6306 of the IRS manual, that if you fill out this 56 and you're going to send a copy of the 56 to the insolvency, it's like the insolvency and quality office in for the region of that taxpayer, which is that offshore account. Okay, and so since that account is offshore, I'm going to show it to you guys because I know sometimes talking about it, you don't know what I'm talking about or you don't understand what I'm talking about. But there is, and it's called, I think it's called AIQ, um, assurance, is it assurance, insolvency and quality? It's some um office where we have to file these 56s. Now, for these 56s, you can fax this over to the AIQ office, okay, for that taxpayer, which is your last name, first name, middle name. Okay, so I was talking about the individuals that set up their own estate private bank and foreign grantor trusts. You were exposed. The IRS told you this, that hey, if you appointed a trustee for your foreign grantor trust, hey, um, do you are you okay with, we're going to shorten TTEE, trustee, to the acronyms TTEE, but TTEE stands for trustee. And in the instructions, okay, you be specific on what type, who is fiduciary of what, because there is a such thing as a master fiduciary, a master trustee. Okay, they are just, this judge is just a plain basic trustee. The reason that we need them to handle these assets is because, like, that deed of trust has to be brokered. There are CUSIP numbers that we don't understand. These, we don't know how to broker these contracts and commodities, and we don't know the different brokerage codes that they're using. But that is that judge's job. Even the clerk, even a lot of these clerks are brokers. The county prosecutor is also a broker. Okay, and so when we're doing this 56, you also can do a 2848 and appoint that prosecutor, that county prosecutor. If that judge do anything other than what you told them to do, you sick that county prosecutor using that 2848. Read that 2848. That 2848 says a lot. It says, hey, what kind of duties do you want this attorney to have? I want them to be a whistleblower. I want them to fill out a 3949A, because, like, some of you guys were like me, like I filled out a bunch of 3949As and they are not going anywhere. And the reason being is because we are not identifying the correct individuals to pay the taxes that's owed to us for usage of our property. We haven't identified them yet. Is it wrong to make ourselves fiduciaries, like when we're doing a draw or bar? No, that's a different scenario. But when we're dealing with, like I said, a foreclosure or a repossession, no, start putting these 56s on them, because now you can, that freedom of information, that FOIA request, look at that 2848. You can make that attorney, tell that attorney, go give me that bond information for this judge who is going to be brokering the decedent's assets and forfeiting them over to the creditor or receiver. Because I'm going to show you that your the title that you use when you sign the form 56 is different from the title that you assign to the fiduciary, the judge. It's different. The judge is going to be the trustee, but you're the receiver. You're in receivership because they are in bankruptcy. Bankruptcy. They're all in bankruptcy. They're bankrupts. The moment that your money got deposited into the court, remember, a liability was also created. So let's say, like, my house was $150,000. Okay. So whoever, if someone goes to deposit my deed of trust down with the court, okay, now the court is holding $150,000, but they are also holding another side of the balance sheet, which is the liability side, because it's reasonable to assume that this money is going to be withdrawn, and this court will be liable for paying this $150,000 out to its beneficiaries or its rightful creditors or owners or whatever you want to call it. The money don't go to them. Bottom line, that money comes to us. Period. Okay. So in on section A, authority, I pick F bankruptcy or assignment for the benefit of creditors, because we are assigning this judge who is a bankrupt. Remember when I talked about in my last video that a reorganization is taking the assets out of these decedent accounts, okay? Taking them out of the mortmain accounts and reorganizing them and putting them into our custody and possession. That is what a reorganization is. And the United States, every corporation in the United States, in all 50 states, are in bankruptcy. All of them are. Every last one of them are in bankruptcy. Okay, under a Title 11 of the United States of the United States Code goes into detail, and I suggest that you read Title 11 of the Bankruptcy Code, where they go over everybody and the Emergency Banking Act. Y'all, listen when I tell you, the Emergency Banking Act talks about how the United States Department of the Treasury is also bankrupt. Every last one of these corporations are bankrupt. Even the treasuries that we think are real treasuries, these treasuries are de facto treasuries. The only real treasury in America is us. Period. There is no real treasury. I know, like Patrick was saying that, but that's like one of the things that I'm not so sure about. I'm not going to say that I disagree with him because I ain't been in this game long enough to, you know, to say definitively. But I'm starting to feel like I have had enough experience with the IRS to come to the conclusion that all of them are de facto, whether they are in Philadelphia or DC or in Puerto Rico. All of them are de facto treasuries. And the only real treasury is us. And that's what we're trying to do. We're trying to reorganize all of this money that we have in these different offshore accounts and place them. They have to come back to the source. You've heard, Patrick, all taxes have to come back to the source. We're trying to reorganize those assets back into our custody. And just like he said, okay, we need to supply a body to these fictional names to make them liable. When they hurt us, when they injure us, when they send in the sheriffs to our houses, when they send in tow trucks to snatch our cars at our driveway. And the whole time we thinking that they had to sign, so we have to send the 56 over to them for them to sign. And they don't. We sign it for them. And everything we sign, you could sign a satisfaction, a mortgage on their behalf. You could sign a release a lien on their behalf. Because every situation that we're in is voluntary. It's all voluntary. So no, I know Patrick came back and said he think he made a mistake on those 56s when he said that we appoint the judges or the clerks or whoever, the sheriff, as a fiduciary. He was not wrong. He just skipped over that section that says that, oh no, you absolutely, the person that signs this form can be a different entity from the named fiduciary because the fiduciary is treated as the taxpayer. And that local court is liable now. However much money that deed raised, that deed of trust, he or she now has to broker down that deed of trust. He or she now has to broker down that promissory note and pay you your money. And if they don't, your enforcement would be that 2848, the county prosecutor. They've been sicking the county prosecutors on us, and the county prosecutors is not here for us. They are here for the corporations, for these judges. But now they best of friends. Go down to the court and look at how the county prosecutor, they best buddies. The fake judges, the de facto judges, the pseudo judges are friends with the county attorney. So they are in a conspiracy against us. But you can remove that with that 2848, and you don't need that attorney to sign. You sign on behalf of that attorney. And then we make them do their job. Now, authority, I said bankruptcy or assignment for the benefit of creditors. Okay. In the instructions, Where is them instructions at? Okay. They go over the different types. Okay, proceedings other than bankruptcy and assignment. Nope, that's not the one. That's something different. Decedent. Okay. See how right here I knew when I read this proceedings other than bankruptcy and assignments for the benefit of creditors. This is a different proceeding, similar fiduciary and aid of foreclosure. Oh, okay. A fiduciary who is appointed or authorized to act as a receiver in a receivership proceeding or similar fiduciary, including a fiduciary in aid of foreclosure. Or now, when you hear the word foreclosure, okay, the word is, oh, we're closing out this account. It's foreclosure. That's really what they are saying. But of course, since they put a FORE, and they spelled it a little bit differently, okay, some of these words are like phonetically you can hear exactly what's being said. Oh, this is foreclosure. But when you look at the word, it says something different. And then when you go read the definition, it's like, oh, foreclosure, somebody coming to take your house because you ain't pay your bills. Okay, and that stokes fear. That scares you, that makes you scared. An assignee for the benefit of creditors must file Form 56 on or within 10 days of date of appointment with the advisory group manager. That, I believe, AG, or is it the AIQ? Okay, so their name is the advisory group manager. And let me think. There is like a whole sheet with all of their numbers for different states, but for these offshore accounts, these 56s must go to the advisory, let me see, what does it say, advisory group manager for foreign accounts or offshore accounts, whichever one it says, outside of the United States, pretty much. Service center where the person from whom the fiduciary is. Oh. The receiver or assignee may also file a separate Form 56 with the service center where the person for whom the fiduciary is acting is required to file a tax return to provide the notice required by Section 6903. Okay, so for this kind of changed my mind a little bit. Proceedings other than bankruptcy and assignments for the benefit of creditors, because this one specifically talks about foreclosure. And of course, you want to aid them in the foreclosure. When they talk about foreclosure, okay, the fraud is using the deed of trust to claim ownership of your physical house. Like that's a scam, okay? The deed of trust is something totally is separate from your house. It has nothing to do with your house, okay? But of course, because we think that the terms in the contract is binding upon us in our minds, we think something different from what the actual case is. And whatever, we act based on what we think or believe. I'm going to dig some more into this right here for people that are going through foreclosure, because we may can use other, see where other and describe, where it says other on the form. Let me see if I can scroll for y'all to see. If other describe, and where it says describe, you're going to enter proceedings other than bankruptcy and assignments for the benefit of creditors. Okay? Because this actually covers foreclosure. However, there is another assignment for the benefit of creditors where So this is bankruptcy, or it says bankruptcy or assignment for the benefit of creditors. So it's either or. If you're a bankruptcy trustee or an assignee for the benefit of creditors, check the box on line 11. Enter the date assets were assigned to you on line 2B. And so the date the assets were assigned to that judge would be the date whoever that plaintiff is, it would be the date that they went and filed a case against you, because what happened is that they entered that deed of trust or that purchase agreement or both. They entered that, they deposited that with the judge as evidence of ownership that they own your house. Okay, and so that would be the date that the assets were assigned to, that they became a trustee the moment that they accepted your deed of trust. Okay, but I want to read some more into this option as well, where we can select other and enter proceedings other than bankruptcy. See, I don't want to do other than bankruptcy. I'll have to think about it. I have to think about it. I would, because technically we're not bankrupt. I'm gonna think it over. I'm gonna think it over, and I want y'all to read 6903. And I want you to read these instructions also, and like tell me what you think. Give me feedback. But I think we should stay in the parameters of bankruptcy, honestly. So line 11, not a line 11, that's 1F is the option that I went with. Um, you can do this for a sheriff. If a sheriff is at your door, oh, Sheriff Jesse L. Harvey, okay, immediately put a 56 on that sheriff. That sheriff is acting as a debt collector. Somebody come and arrest your husband or arrest your wife, immediately put a form 56 on that police officer and the 56F on the police department, because now they owe you money. They're fiduciaries now. They have taken your body as a deposit. They're holding your body as collateral. Okay. Back to, sorry. All right. Okay, so for 2B, if box 1C, E, or 1F or 1G is checked, enter the date of appointment. And remember, I said the date you received the case, but you can enter the date that whoever the plaintiff is, the date that they deposited your asset with the court. Um, the nature of liability and tax notices, okay, they owe you income and estate taxes. And honestly, I kind of feel like they owe employment and excise. I check all of them, to be honest. Yeah. I check every last, except generation skipping transfer and gift. Federal tax form number, check all that apply. Let's do the 1041, and all applicable 1099s. More than likely, the primary form that judge is going to use is a 1099B, because he has to broker and barter that contract, and we should receive a 1099B showing like the settlement of the funds. So I don't know, like, if they're going to, like, the court can issue a check. I would assume that they have the ability to, or if they're just going to give a 1099B, and then you could use that 1099B to claim whatever that amount is on that 1099B that the judge brokered. Okay, so you see how up here what I was saying to you guys, the judge's name, comma TTEE, because that judge is acting as a trustee. Okay, we appoint the judge as a trustee, but we are down here as a receiver. Okay, because we're in receivership for the assets that this trustee brokers. We're receiving because this is our person. This person belongs to us and you owe us rent for usage of that property. You sign as the receiver. Now, the 56F, let's see. Okay, so the 56F also has to go with the 56. The name of the court, okay? The court EIN number, the address, city, state. The court uh the court is bankrupt. It is insolvent, okay? It is what makes a corporation bankrupt, okay? Like to try to help you guys with understanding. The reason that the court is bankrupt is because its liabilities likely exceeds its assets, meaning that just about everything that's deposited with the court is someone else's, their assets, is someone else's time and labor or money, whatever you want to call it, has been deposited with the court. But whatever the value of that asset is, it is offset by a liability. So if a person comes in and deposits a, let's say, a deed of trust, okay, valued at $100,000, automatically a liability of a negative $100,000 is created, meaning that the bankruptcy court has $0. It has $0. And the only money that the court, like the judges themselves, make is maybe the $50 or $100, however much they charge to hear a case. That's the only money that they're supposed to make. They're supposed to be working for fees, but they big time, and because now they stealing houses from people, so that's way more lucrative. Okay, finessing people and scamming people is much more lucrative than working for these little petty $50 or $100 they might make from people filing small claims in their courts. They'll get richer faster by stealing your house. The name of the court goes here. Employer identification number. Okay. The fiduciary's name, I will put the estate. The estate is overseeing like that. When we opened our estate, okay, that estate was open for asset exchange for banking purposes to pick up the assets that we left behind. Was that deed of trust not an asset that we left behind? The appropriate entity, in my opinion, you can also use, if you want to use your private bank, use your private bank. But in this instance, like if you're dealing with a foreclosure, I would use the estate. The fiduciary's name, the name of your estate goes here. Contact person, Christina. Okay, address of fiduciary, into your home address or PO box, whichever address you used on that CP 575 notice that you got back from the IRS showing the creation of your estate. You use that exact same address. Check the applicable box if the fiduciary is a what? Is a receiver. Is a receiver. Let's see. I don't fill out 16, 18. I don't fill out those boxes. I've always left those blank. Um Authority, appointment of receiver. Okay, appointment of receiver. Tax notices, employment excise, financial institution listed, indicate notices written community tax this include the type and tax. Okay, so like some people, how when did you first get your mortgage? What year? So you write TY, which is an acronym for tax year, and then you write all the years that that mortgage contract you got to be paid for. They owe taxes for all those years. When I say they, I'm talking about the judge owes taxes for all those years. And you put that down on that 56F. Be sure to do let me think, let me be sure because Some of you guys like asked me the question like how many 56s do I need to do? You want a 56 for any entity that you're acting on behalf of. Okay? In this instance, we are not acting, we are making them perform. We're making them act as the trustee, and we're signing as a receiver. We're the receiver acting on behalf of the estate. So the name on this 56 needs to be the name like how it is written. How is your executor's name written? You're not going to call it an executor, but the estate is in receivership. And the executor is the person. The person, it is the individual to receive the asset. It's going to come to the estate, and then once it comes to the estate, the executor is going to disperse it to the beneficiaries, which is you. These are your persons. This is what Patrick meant when he said you send your persons to do your dirty work. Okay, so this video is getting up to an hour long. Oh, one other thing, like for, like I said, for any evictions, um, unlawful detainers, enter that court information on down here and where it says part 3. It's real easy. You don't need me to hold your hand through every step of the way. Y'all got this. Some of y'all are just like, you're so panicked and you think you need to run something by me. No, you're an adult. You're capable of making good choices and decisions. Read it. What does it say? What is it asking you for? And make a decision. Okay, so enter the name of the court. What date did they say the proceedings were going to start? The address of the court, the case number. Okay, enter all the information down here. Now, let me see, there is a section for, what did they call it? They called it the advisory group manager. Let's see. Okay, so here it is. This is the phone number for the advisory consolidated. Is this the one? Let me make sure. Okay, yes, collection advisory offices. Let's see. Okay, so you see how they have the different states? The the 56 and the 56Fs should go here. Okay, and it says number 7. So we scroll down and we find number 7, and this is where it goes. Oh, they got the nerve. Plantation, Florida. That's what it feels like, a plantation. Okay, so this is where the 56 and the 56F would go. Okay, for international, including Puerto Rico. Remember, because that last name, that name on the driver's license, that name on the passport, that name, look at your DD24, look at any identification you've ever received. That name is written where your last name is first, and then they put your first name in the middle, and then they put your middle name last. Okay, those are offshore accounts or mortmain accounts that Patrick was talking about. It's publication to the town. I'm sorry, I was just reading over what it said at the top. Okay, so y'all saw how I got to the collection advisory office's contact information. I wonder where did I got AIQ is in my head. Assurance, Insolvency, and Quality Office. I don't know why that name or some similar name is like, that name is like stuck in my mind. Like I've seen that, those acronyms somewhere. Maybe I'm mixing, I don't know. I don't know. I'm tired. I could just, I don't know. I could just be off uh in what I'm thinking. Okay. Advisory consolidated receipts. Purchase money. Oh, hold on. Wait a minute. Estate tax advisory group. Questions about federal estate tax liens. Deceased person. IRS forms or additional information. Centralized lien operations. And that's what Patrick kept saying, that estate creates a lien on any asset issued by the SSN, our public banker. He said that the moment that we create an estate, that estate creates a lien on all of our property, borrowing to purchase property where taxes are owed. Refinancing using property subject. Certificate of, oh, somebody laughed at me and said, you making a fake certificate of discharge? No. If a bankrupt corporation can make certificates of discharge, and now we know without a shadow of a doubt that we can sign on behalf of a corporation, we can bind them to the terms of whatever is stated in our certificate. If the IRS can create a certificate of discharge, we can too. Okay, so like I'm starting to take y'all advice. I'm just going to kind of drown out the haters and the naysayers, because really what's going on, what y'all don't get to see, is that these people talk all this smack, all this stuff behind the scenes. They're actually taking my suggestions behind the scenes, but publicly and in the comments, they talking smack, and it's just annoying. Okay? It's just annoying. We're all here for a common cause, a common reason, and that's to gain control over our accounts. So that's pretty much all I got for you guys. This video is over an hour, which is longer than what I wanted it, but I had to share. I had to share that with you guys. I think that this is going to be you I hate to say it, but a quick remedy. I hate to say quick remedies, but no, this 56, you can sign this 56 and that 56F, and you get that into those advisory offices as quickly as possible. And you let that judge know that, hey, you've been assigned as a trustee, okay, to broker that deed of trust that was deposited with your financial institution. You now have an obligation, okay? And you do that 2848, and you appoint that district attorney, okay? And on the 2848, it says, what do you want this attorney to do? Oh, I want them to do a FOIA request for me, okay? You tell that attorney to go get that judge's bond, because if you do something I don't like, okay, and you can instruct them, give you the 2848, read it. It tells you, like, what powers do you want to give this attorney? I wanted to have the authority to take this judge's bond into bankruptcy and liquidate it and forfeit the proceeds to me for harm. If that judge harms you, if they don't broker down that contract and forfeit those assets over to you. All right. So I hope y'all are all doing well. I don't think I have any new developments. I'm still working behind the scenes, you guys, trying to, like I say all the time, trying to make the business better, trying to streamline services, trying to answer emails, okay, to get back with you guys as quickly as I can. But other than that, I really have nothing. We'll talk, okay? Bye.